we're going to talk about oral arguments and speaking in class and public speaking. I'm going to start by introducing BarMax and myself. Then we'll go through talking in class and how to manage any anxiety that you might have about that. And then from there, we will talk more in depth about oral arguments. So, all right, there we go. So, I imagine that many of you are about to face your first oral argument and you're thinking, what do I do, right? What do I say? What's how do I prepare even? So we're going to talk about that today. Let me talk a little bit about myself. So I have been teaching in various law schools since 2007. And with COVID, moved over to BarMax where I can work from home because my kids were home. And so this was a really great fit. And I really love what we do here, right? We help folks prepare for the bar, hence the name BarMax, but we also help folks prepare for law school, which was a big part of my job in my former life, right? I started out working in academic success. So, kind of helping folks adjust to law school and the expectations of law school and how do you do law school, as well as helping folks prepare for the bar exam. I have taught legal writing, including legal writing courses that involved an oral argument component. I've also almost every year served as a volunteer oral argument judge. And I have some experience with presenting an oral argument, there we go, in front of judges as well. So lots of thoughts about that and how to use this to your advantage. So let's say that you're like, Jen, your argument was great, your presentation was great. It was super helpful, but I need somebody to look at my oral argument and listen to it with me. And would you be willing to do that? Yeah, absolutely. And you can buy some hours and come see me. Or maybe you think, gosh, what I really need help with is writing my exams. Can you help with that? Absolutely. Come see me, right? Or, hey, I wrote my first draft. Can I talk about it with you? Yes, absolutely. So, we do have various packages that are available. Let's jump into speaking in class. Many of us, here's the deal, guys, right? Like public speaking routinely ranks as one of the most common fears, right? It's above spiders. I think the only thing that's in front of it is death. Public speaking is scary for a lot of us. And I think sometimes that's true, even speaking in class, right? One, this is really different from probably whatever happened in your undergrad, right? So in undergrad, your prof probably said, hey, we're going to talk about, I don't know, whatever it is, the development of infants, right? Or the concepts of, Erik Erikson. I did an educational psychology minor. Erik Erikson, right? And you go home and you read your chapter on Erik Erikson, and then you come to class and your professor says, here are the things that you should know about this topic. And then at the end of the unit, you have a quiz, right away if you understand or don't understand the material, and you can adjust your studying. Law school's not like that, right? You've been through a semester, probably maybe even 2 years, you might even be in your second year at this point. That's not how it's going to happen. We're going to hand you a stack of cases about, say, false imprisonment. You're going to be expected to read those cases from your casebook and to come to class ready to talk about them. And maybe your professor's going to call on you. Maybe she's going to call on someone else. And then you're going to have a conversation where your professor is hopefully kind of trying to figure out what those cases meant, right? But there can be this pressure that you're supposed to know, what do those topics mean, right? Like what is, false imprisonment? What exactly is the merchant's privilege, sometimes called shopkeeper's privilege, or the privilege of detention? Do all those three terms mean the same thing? And your prof's going to ask you those questions. Ideally, the Socratic method is meant with, that's what we call that, the Socratic method, where the professor is, questioning the student. Ideally, the Socratic method is meant to be a joint search for truth. Unfortunately, sometimes it can feel like your professor has a particular answer or a particular thing that she wants you to say, and she's just not telling you whatever that is, right? She's just talking about, looking for a certain thing, and it can feel like she's grilling you, right? She's just putting you on the spot. She's asking you a ton of questions, and we hope you understand those questions. And then there are other folks who are going to, who feel, you're listening to someone else answer the questions, and you're like, was that right? Was that not right? I don't know. And you're just hoping you're not the one that's going to get called on. So let's talk about, beyond that, what's going on? How do you do well in class? What are you supposed to be doing when your professor is asking those questions? So one of the things you want to think about is that your professor is asking those questions, as we said, kind of as hopefully in a joint search for truth, but it's also an indication of what she values, and it's an indication of the types of questions she might be likely to ask you on the exam, right? So if your professor says, and what do we believe is the purpose of this statute? Your prof is going to care about policy and why was this material or this statute passed, right? Why did the court hold the way that it did? If your professor says, and what color was the car, right? Your professor very much values intense factual analysis. She wants a close reading of the case. So you can kind of look at that and predict that. That is important, not just for thinking about, the exam, but also because it allows you to prepare how you will respond before you get to class, right? So and by the way, if you're briefing, hopefully you are, but your briefs should change based on what it seems like your professor values, right? So if your professor is, often starting classes with, and what was the court's purpose in, deciding this way, or how did this change the, previous, laws in this matter? You want to be aware of that, and that should change the way that you prepare, right? So how do we get good at speaking in class? So the first thing that I'm going to say is, don't be afraid to build on previous discussion, right? So if your professor, is talking with another student about the purpose of the statute, don't be afraid to chime in and say, it's worth noting that, this departed from previous law or, however you can build on that. Don't feel like you have to recreate it from scratch. Don't be afraid to disagree. One of the times when I was talking about this with some students, I had a student come up afterwards and he was like, Jen, I am afraid to disagree, right? I'm a first year law student and you're telling me I should disagree with, the Supreme Court about the way that they decided? Yes, absolutely, right? Notice that the Supreme Court disagrees with themselves, right? How often do we have a concurrence, a dissent, a majority and a minority, and maybe we have a bunch of those, and there's no sort of uniform decision there. How often does the Supreme Court come back and overrule itself? How often does one judge, or a panel of judges reverse a previous judge's decision and send it back down? It happens. And this is what you're being prepared to do. You're being prepared to disagree with other lawyers, other judges, and make arguments about why they're wrong. It's okay to do that as long as you're being respectful, right? What we don't want is, that person's just an idiot, right? No, that's not going to work. But, I disagree with the court's reasoning here for reasons, right? Perfectly fine. And in fact, sometimes your professor wants that, right? So if I'm teaching a doctrinal course, I may want students to disagree with me because that allows us to bring in both sides of the argument. Otherwise, I'm kind of up there trying to give, some scholars believe this, but other scholars believe that. But if I say some scholars believe this and somebody raises their hand and says, what about this other idea? I get to say, yes, exactly. And here's what some scholars have said about your idea. So don't be afraid to disagree. Try to make connections between your cases. And of course, you're trying to do this anyway in your outline, right? You're trying to say, hey, case number 1 was the precursor to case number 2, and you can see the court refining its reasoning, or case number 2 overruled case number 1, or case number 2 presents an exception to the general rule presented in case number 2. When we talk about synthesis, that's what we mean. How do these cases interrelate? So one of the things that a lot of first-year students hear is, hey, you got to work on your synthesis. What do we mean by synthesis? One of the things we mean is, how do these cases connect? And hey, by the way, that is something you can talk about in class, right? So you can say, well, the court here was overruling the previous holding, and based on these facts or whatever. It really should be a discussion, right? So it should be the kind of thing that you are, they're not trying to, your profs are not trying to put you on the spot. They're trying to ask you questions and get a sense of what you're thinking. Instead of having that weekly quiz where you get to know, did I know this material or not? You're getting your in-class discussion. And that in-class discussion is meant to allow you to evaluate whether or not you are providing the analysis your professor wants, right? So I said judge here, but this is going to apply to your in-class speaking as well. So for example, I had a professor who would often kind of go, so what you're saying is, and then he would rephrase whatever you said correctly, right? So, and you could be having this moment of like, nah, I mean, I wish I was that brilliant, but no, that wasn't what I was saying. But what he was trying to do there was to guide us onto the path, right? Of like, this is what this case was supposed to be, or this is what I was trying to get out of this. So really listen to that conversation and make sure that you're picking up on sort of the tells, if you will, that the professor might be providing. Also think about the fact that when the professor is asking other students questions, you should be paying attention not just to their answers, but to their modes of analysis. So how are they going about providing that answer? And what does the professor think about it? So, I had another professor that would keep asking the same question over and over again until somebody would provide her the answer she wanted, right? And then she would move on. Well, make sure you write down whatever that last answer was, because that's apparently what she wants, right? So think about kind of, the conversation that you're having. Think about that kind of analysis that your judge wants. And I'm going to also say, think about volunteering, right? Most profs are not going to call on you more than once in a class. Some will, but most will not. And so if you volunteer, if you decide ahead of time, I want to talk about the third case in today's reading, volunteer. When that case comes up, say what you want to say. That allows you to prepare ahead of time so that you're not sitting there, waiting for the prof to call on you. Instead, you're saying you're able to provide, you're able to be in control here a little bit, right? It allows you to steer it. So that's something to be aware of. Let's say that the professor calls on you and you are thinking, oh my goodness gracious, I don't know what she's even asking me. I don't know how to answer this question. I'm not sure what I'm supposed to say here. What do you do? So, and this, by the way, you can use some of this in oral argument as well. So the first thing that I want you to do is I want you to take a minute, not a literal minute, not 60 seconds, but, a couple of seconds. And I want you to kind of take a deep breath. I want you to pull your shoulders back. I want you to sit up straight. And I want you to just take a moment to consider what the professor asked you. Here's the thing. Everybody else in class is going, oh, thank goodness I wasn't the one who got called on, right? So they're all just glad they're not getting called on. That means that you taking that moment isn't going to interrupt the flow at all. And they're probably not even going to notice it. So that's the first thing you're going to do. And I would tell you that even if you were 100% sure what the answer was, I still want you to take that deep breath, put your shoulders back, sit up straight, and answer the question, right? Second, you can think aloud for a few minutes, right? So you could say, well, thinking about, what the facts that the court seem to find persuasive here are, the breed of the dog and the fact that it was provoked. And so it seems to me that the purpose of this statute, at least in the court's eyes, blah, 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 right? And you can kind of think aloud for a little bit. Remember that one of the points of the conversation is so that the professor can evaluate the way that you're solving the problem. Not just that the problem is solved, but how do you solve the problem? So that thinking aloud actually gives that professor that information, and it can actually further the conversation, right? Because the professor can say something like, well, notice that they only mentioned the dog's breed once, but they mentioned the provocation several times. Does that alter your analysis at all? Well, yes, it does, or no, it doesn't. And here's why. But it allows the professor to kind of deal with that, right? Again, let's say that there's, a question and you've done your deep breath, you put your shoulders back, you're kind of like deer in headlights. I don't even know what the professor's trying to ask me here. You can totally rephrase. So you can say, as I understand it, what you're asking is whether the court considered the dog's breed an essential fact when they were deciding whether or not it was provoked to bite the child. Is that correct? All you're doing right there is repeating what the professor said, right? Here's what that does. One, title right there, buying time. It's going to give you a few minutes to think about what you want to say next. Two, it tells the professor that you're listening, right? You weren't, dinking around on your computer and pulling up ESPN or the New York Times or today's Wordle. You were paying attention. You just trying to figure out what to say. And it allows the professor to, provide substantive feedback as well, to say like, oh, that is what I said, but what I'm trying to convey is X, or yes, that is what I'm trying to ask, or what have you. You can also use this with previous comments from your colleagues, right? What I heard Sam say was that the court was most convinced by the fact that the child stepped on the dog's tail. I think that's true, but it's also important to note that, she did so unintentionally, right? Or, whatever you need to say to kind of rephrase it, right? Okay. I want you to look at the professor. This, gets a little, let me take a little sip of water here, which is something I'm going to talk about in a second. Look at your professor and smile if you can, right? Smiling will actually release some chemicals in your brain that will help you feel a little bit calmer. You don't want to look sort of unhappy that the professor called on you, right? Ideally, even though we know it can be stressful, right? But ideally, you get that the professor is just trying to talk with you, right? So look at them and make that eye contact and smile. If you are someone where making eye contact feels a little weird, a lot of us feel this way. You can look at their forehead, right? You can just look right here and it totally looks like you're having eye contact. People can't necessarily tell that you're not looking at them. Definitely better than if you are sitting there with your book and you're like, oh my gosh, where is it, right? But looking at your professor says, Jen, and you look up and you give that eye contact and maybe you smile, it conveys a different message, right? I want you to think about speaking loudly. So, making sure that people behind you can hear, making sure that people in front of you that can hear. This is particularly important if you are in a large, like lecture hall type class. So if you are in a class that has, 50, 60, 70 people in it, making sure that you're speaking loudly is important, right? And hey, by the way, if you're in that class and the student says something, you don't quite catch it, but it seems like the professor likes it, right? So my class where my professor would sometimes just ask the same question over and over again until somebody gave the correct answer, and then she would stop asking the question. Okay, write down the name of the person who answered the final question. So you can talk to them afterwards and be like, hey, So Professor Smith seemed to really enjoy or really, be happy with your answer to such and such question. I got to admit, I didn't hear what you said. You want to think about being as articulate as possible. Notice that right there, I just said and it happens. Or we say things like, like is one, or we do things that kind of fill that space, right? It's not bad. We don't hate it or anything, but it is something to be aware of. Some of it is fine. A lot of it can be, your professor sitting there thinking like, are you super anxious? Like, do you not know what you want to say? Have you not prepared for this course? So be aware of it. It's not a fatal flaw or anything, but it's just something to notice, right? The other thing that you can do is kind of look at other lawyers, other speeches, other advocates, and think about how are they speaking, and what are they doing, and can you emulate those modes of speaking, right? So whatever vocabulary they use, or how they structure their sentences, even how quickly they speak, right? So one of the things that people used to say about former President Obama, right? Somebody who was a law professor for a bit there, was how slowly he would speak, and he would have these pauses. So if you're like me and you tend to talk too fast, watching some of those and seeing how he pauses and gives people a minute to digest what he said can be really helpful. So poke around. If you just Google like 100 greatest speeches, right? And you can kind of see like, what are these other advocates or speakers doing that works for them? And how do we emulate that if we can, right? Can you think about, using analogies the way that former President George W. Bush did, right? 1,000 points of light. Okay, do you enjoy that analogy? Does that work for you? Do you want to be someone who uses analogies when you speak? Have that consideration. When you're thinking about class, right, and what you're going to say, I want you to think about what you're going to say ahead of time. So for every single case, right, have something to say, and maybe you make a little note of it in your brief. And that thing that you're going to say can be I noticed that this case seems to be overruling whatever, or I noticed that the court really seems to consider this fact essential, but think about it ahead of time. Then I want you to practice that. Ideally, this is with a study group or study buddy, somebody else who has read this case and can have a conversation with you about it. But worst comes to worst, like any living creature or stuffed animal or even the mirror will work, so that you can have that moment of not just saying it, but being conscious of how you're saying it, not just planning what you're going to say, but actually saying it. Here's what we know works for anxiety, especially school-related anxiety. One, being over-prepared, right? So if you are someone who has that public speaking anxiety, which is most of us, you're going to need to prepare more than that minority that doesn't have that anxiety. So over preparation and practice, right? And particularly practice in similar situations. So think about, some TV show you've watched where the psychiatrist takes shows the person a picture of a spider, and then, lets them stand next to a spider in a cage, and is eventually like putting a tarantula on the person's hand. You want to do the same thing. The more practice you can get yourself in, the more realistic scenarios, the less your anxiety will be. One of the ways that you can do that is to think about what your professor might ask. So we've talked about clues that the professor will give in class, right? She always asks about the history, or she always wants to know, how did we end up here? What was the, case history? Where did it start? How did we end up in the appeals court? But also look at the notes that follow the cases, right? Where they say, what if, this fact had been different? Consider the case of whatever. And it's a quick little blurb about that case. Or sometimes there are questions before or after, and many professors are going to base their questions on that. Okay, so shifting gears a little bit, right? Although a lot of what you're doing in class is helping you prepare for oral argument, let's shift specifically to oral argument. So the first thing that I'm going to tell you, just like we said, like, hey, public speaking is a super common fear. Having that moment of anxiety around oral arguments is also important, right? It's a good thing. Being a little bit anxious before you give your oral argument is what gets you preparing, right? Otherwise, you don't prepare. Otherwise, you're like, it'll be fine, no big deal. I have a friend who has done probably hundreds of arguments in front of the Ninth Circuit. And one of the things that he tells me is he is still anxious every single time. And he will go so far as to say, if you're not anxious, it's probably time to stop presenting those arguments. So same for you guys, right? It's your first time giving this argument. You should, or maybe it's your second time if you're a second year student and your school has a class that allows you to do that, or you're prepping for moot court, or who knows, right? I want you to think about, a little bit of anxiety is okay. Where we don't want you to be is in a place of crippling anxiety. So that little bit of anxiety, not a bad thing. We actually want you to be a little bit anxious. So if you're feeling a little bit anxious, that's not a sign that anything's wrong. That's not a sign that you need to be particularly worried. That's actually a good thing. All right. So when does oral argument happen and what's the point of it? So in real life, here's what happens. You've written your brief, your opposing counsel has written their brief. You may even have an opportunity to provide a reply brief. All of that's been filed, and the clerks, so the judges' clerks, some judges at the appellate level will have 2 clerks, some are still just having 1. That's been submitted. The clerk has read it, the judge has read it, the judge and the clerk, or the clerk has briefed the material for the judge. Sometimes the judges have even made up their mind, right? So sometimes the judge is even sitting there thinking, plaintiff's kind of got the winning argument here, but I guess, I want to ask a few questions of defense counsel. And so an oral argument is going to happen after all of that. What are we using oral argument for as advocates? What are we using it for? We're going to clarify anything that still might seem unclear, right? If you have something really complicated to present in your brief and you think to yourself, like, I think I did a good job with this, but maybe I should, present it again, or maybe I want a different way to present it. You can do that. If the judge has a question, she might want, to have an oral argument. Sometimes the judge is using your oral argument to get the other judges to agree, right? So you submitted all your paperwork. The judges have read it. Maybe there's a panel of 3 judges, right? You're at the appellate level rather than at the Supreme Court type level. So maybe it's 3 judges. And your judge may very well be sort of saying, like, I'm going to use your argument to tap into whatever objections the other judges had to your position, right? So don't necessarily think that every question is meant to be a trick, right? Again, it's a discussion. And sometimes judge number 1 is asking you questions that they know if you can present a really good argument on this issue, judge number 2 is going to find for you. So don't necessarily feel like those questions are a trick. For our perspective, right, this is your last chance to give that argument to the judge, right? It's you've already put in all your paperwork. This is it. Is there anything else that you want to add or say? What do you need to have a good oral argument? So I've mentioned that, I've previously judged oral argument competitions. What am I looking for? What's a good thing to have? So obviously, your oral argument's going to have a good argument, right? Which means it's got to have good substantive content. What does that mean? Well, one thing that you need to have is going to be a theme. So what's your theme? So for example, years ago, we had an oral argument problem where the petitioner was wearing sort of a skimpy waitressing outfit. And when she came back from maternity leave, her boss told her, your outfit doesn't look as good on you anymore. You're going to have to, lose some weight before you're going to be able to be a waitress. We're going to assign you to this lesser paying position. Okay, that was the problem. So what's your theme, right? Is if you're representing the plaintiff, maybe this is a theme about how your client has experienced discrimination based on her physical appearance. If you are representing the defense, maybe your theme is, we value this employee, but at the end of the day, our customers are coming here for a particular experience, and we only can survive as a business giving jobs to however many people if we can provide that experience. Be aware of kind of, you don't necessarily want your theme to be, use your theme as something that you can come back to, right? So one thing that you can do as an advocate, as you are preparing, look at some of the famous cases, right? So if you look at Brown versus Board, one thing that happened here that was really interesting was the attorneys actually brought in scientific evidence demonstrating that segregation was negatively impacting students. And so that was the theme, right? It was coming back again and again to this idea of, separation can never be equal. All right. So the first thing you want to have is a theme. Second thing you want to have is a roadmap. Notice that when we started today, I said, first, I'm going to tell you a little bit about me and about BarMax. Then I'm going to tell you a little bit about speaking in class and how to manage that. And then I'm going to talk about my oral argument strategy. That's a roadmap. Those roadmaps can just be drawn from the section headings in your brief. You want to have good rule statements, right? Which again, are just going to come from your brief. What's in your brief and can you pull those out? And you want to have fact comparisons to whatever the key cases are. So you want to make sure you kind of know what the key cases are, and you want to be able to say, hey, that case doesn't apply here because it was about an adoption by an uncle. In our case, it's about an adoption by a step parent. You want to have a polished presentation. What does that mean, right? We said in the beginning, prepare, practice, polish. So what does that mean? One thing it means is that you have anticipated sort of substantively, what are the potential arguments that you might hear? What are the potential questions you might get? What's the other side likely to say? And you want to think about how you're going to say things. So, how would that appear? And your tone can be very formal, or it can be formal with a little bit of a more conversational tone. You don't want to be casual. So, be very careful with things like humor, avoid slang. You want to present as, a polished, formal presentation. For some of us, we might lean towards a little bit less polished, more conversational, but you don't want to dip into being casual. See if I can make this work. Oops. Nope, that is not showing for you. Hang on while I pull up that
Do you remember
video.
your first oral argument?
Oh, sure.
Okay.
Yes.
So go there. And I want to make that big. And then I will go, oops, not there, here. And I will do share screen. We will go to the video. We will share sound and optimize for video clip. Oops. There we go.
Absolutely. A case called United States against Halper. I was very nervous, but I was very nervous when I did my last oral argument as well. I think if you're a lawyer appearing before the Supreme Court and you're not very nervous, you don't really understand what's going on.
This is a question for all the members of the bar out there, I guess, and for all those attorneys who eventually find themselves lucky enough to have a case before the court. What is it that you wish you had known about the process when you were on that side that you now know?
Everybody tells a lawyer in that position, you have to answer the questions. Don't try to avoid the questions or distinguish your case in any way. I hope I did that when I was a lawyer, but the importance of that is very accentuated. I appreciate it so much more now that I'm on the other side of the bench. You have to appreciate that the justices are engaged in the process of trying to help themselves decide the case correctly. So they're going to ask hard questions. They're going to ask questions that don't put your case in the best possible light, and you need to appreciate that. It's good to establish, I think I didn't appreciate this as much as I should have, some dispassion. Yes, you want to have a certain level of zeal and commitment to your client's cause. The justices know that. But when they ask you a question about a difficult case, it's better to sometimes say, I appreciate that that case doesn't support my side. I appreciate that that causes us some difficulty. Here's why I think you shouldn't rely so heavily on that case, as opposed to as soon as they ask us, no, that case doesn't hurt us at all, and here's why. They like you to be part of the process that is helping them come to the right result. They understand you've got a client to represent, and they expect you to do that. But if you can convince them that you're on their side in helping them reach the right decision, as opposed to something they have to push against to get you to give an answer, I think that's very helpful, not only to the court, but also to your client.
Okay, so notice the overlap there, right? We said that ideally what's going on in class is that you and your professor are engaged in this joint search for truth. That's what you're doing in oral argument. And notice that, it's okay to sort of say, hey, this case is, against us, or this case, gives us some trouble. Here's what should happen in spite of that. So kind of think about the idea that everything you've been doing in class is preparing you for that oral argument. All right, what are you going to say? The first thing is that I want you to know what your argument is. I know that sounds obvious, but not just kind of what you think the big issue is, but how is it going to be organized? What do you need to talk about first? What are the preliminary issues you need to get out of the way? Maybe you need to establish what law is going to apply, right? You need to establish that, the law of California is going to apply, not the law of Oregon. Maybe you need to establish that the judges have jurisdiction to decide this case, right? It's not moot. It's ripe to be decided. So kind of think about what your organization is going to be and how you're going to present that information. You want to try to be organized, not just in your thoughts, but also in your notes and your brief and everything, and also in the way that you present that information. I want you to think about, how can I be concise? So, how can I go in and give the judge, if you had to give the so-called elevator speech, right? The idea that like you're trapped in an elevator with somebody and they ask you a question, can you share the topic in the time it takes to get to the next floor? So make sure you kind of know what the gist of your argument is. I want you to know what your main points are. And what I would suggest for main points is going to be one, kind of think about what are the 2 or 3 things that you have to get out there. Like if you don't get those things out, you really have not done your argument, right? Like if there's no argument has occurred if you don't bring those 2 or 3 things in. Then think about kind of your what are the things you'd like to throw out there if you get a chance? And last, what would be some bonus points if you could? Be aware of what's good for you, be aware of what's not good for you, right? So like Justice Roberts said, be sure that you can say, hey, I know that, the Jones case is not good for our side, but here's why it's, inapplicable here. So kind of be aware of what's helpful for you and also what's not. A lot of times we're going to talk about sort of the temperature of the bench, right? So the ice cold bench is kind of like the judge is just kind of sitting there looking at you, and you get to deliver what is essentially a speech, right? Maybe you get 2 or 3 questions. They're just kind of like not engaged, right? Most of the time, you're not going to get that. Most of the time, you're going to get questions. You're not going to be able to just go up there and deliver your argument like it was a speech. It's really much more of a conversation. As we go across the spectrum, right, the bench can get hotter, meaning that there's sort of rapid fire questions coming at you, right? That's at its hottest. Be aware that there's basically 3 types of questions. So one is going to be a hypothetical, right? Where we sort of say, well, what if instead of coming back from maternity leave, she had simply gained weight? Don't actors frequently have, clauses relating to their appearance in their contracts? How is this different? Where the judge is giving you some kind of a hypothetical, and you want to have prepared for that. So, maybe you can just address that. You can answer that. If you're the defense, maybe what you say is, exactly, Your Honor, the waitresses here are not just food servers; they are also entertainment providers, and so we do expect them to adhere to the appearance clause, right? Or maybe what you say is, Your Honor, I am not entirely sure what would happen there, but it doesn't apply to us because our client is a food server, not an actress, right? Think about the other second type of question, which is going to be the so-called softball, right? This is the judge who's asking you something easy. I mentioned, sometimes, I've had the opportunity to observe or participate in arguments before, involving practicing lawyers and judges, not just in the law school context. So I had a dear friend of mine who was presenting an oral argument in front of the state Supreme Court. And her situation was that her client was imprisoned and was denied his opportunity to review his trial transcript, which you can't do that, right? And so the judge asked her, what remedy do you want? And I think, she interpreted that as a hostile question, but, he had been denied his trial transcript for some number of years. The judge on his case had died. The witnesses were no longer available. The obvious answer is, he needs to be released, right? But I think she was super anxious and she was anticipating that to be a difficult question. And so she simply kind of danced around it, where it was a softball. It was an easy question where that judge was trying to signal to her, this is the thing that would convince my colleagues on the bench. And then, of course, we get the questions we're all dreading, which is the judge who's asking you the hard stuff, right? And you need to be prepared for any of those types of questions. All right. What actually happens in an oral argument? Well, the first thing that you're going to do is you're going to come up and give an introduction. And you should have your introduction memorized. And it's usually pretty brief and also formulaic. So you're going to say your name and who you represent, right? May it please the court, my name is Jennifer Carr. I represent the plaintiff, Joanna Smith, in this matter. If you're going to need rebuttal time, be sure to ask for it. I'd like 3 minutes for my rebuttal. And then you're going to provide your theme. This is a case about discrimination in the workplace, or whatever you've decided the theme is. Then ask the judge for what you want. My client asks this court to reverse the lower court's ruling for, 3 reasons or however many reasons, right? And that's going to lead you into your roadmap where you're going to say, first, my client is not an actress. Rather, she's simply a server whose role it is to provide drinks. Second, her outfit is a uniform, not a costume, and should be adjusted according to any weight gain or weight loss. And third, she's experiencing this discrimination as a direct result of pregnancy, which makes it gender-based, or whatever your argument is going to be, right? So you're going to start off with that. And all of this part should be memorized at least up until the roadmap. If you don't have the roadmap part memorized, that's okay. If you need to glance down and look at that roadmap, fine. But otherwise, it should be memorized. Then you're going to start off. You're going to say, first, let's, as previously explained, my client is a server and not a entertainer. And the case of Smith versus Jones holds that when appearance clauses can only apply when the employee is an entertainer. And you explain that, right? Second, key thing to take away from this, I want you to be sure that you are explaining the result that the judges should draw, right? What's the conclusion of this? Here, Miss Smith is much like the plaintiff in this case, and the court should find similarly, namely that she is not an entertainer, but merely a server or whatever. You're going to do the same thing with issue 2. When you get to the end, right? So the judge, they've been 3 minutes, 2 minutes, 1 minute, it's time to stop. You're going to say, and for the foregoing reasons, we request this court to affirm or reverse. Super quick. Or you could go the longer version. Therefore, because she is an employee and not an entertainer, because her outfit is a uniform and not a costume, and because she's experiencing gender-based discrimination, we request that this court reverse the lower court's ruling. So it can be kind of shorter or longer. Let's say that you are in the middle of the judges asking you a question, right? Judge 1 has asked you a question and the timekeeper calls time. You can say, Your Honors, may I briefly conclude? If that's what happens, right? You're in the middle of answering the question, you are time is called, you finish answering the question, and then you give your short conclusion, okay? Like we said, I want you to think about what your main points are, and I want you to think about your structure. So there's this thing called primacy and recency. We remember what comes first, and we remember what is most recent or last. What that means is you can bury your weaker arguments kind of in the middle, begin with your strong argument, end with your strong argument. Again, address those potential weaknesses. I want you to make sure that you memorize as much as you can and think about what should trigger particular responses, right? Oh, if the judges ask me about the Hunterson case, I'm going to respond in whatever the way is. Or if the judges ask me to explain why she's not an entertainer, here's what I'm going to say. And have a note about what you're going to say about that. All right, let's say that you are not the plaintiff, you're the defendant, or you're the plaintiff, but you're giving your rebuttal. Make sure that you listen to what the other side says. So if you're the defendant, you're obviously going to walk in with your own points drawn from your own brief and from your own research, right? Just like the plaintiff has, but listen to what your plaintiff is saying. Can you respond to that? Listen to what the judge's questions are whenever the other side argues. So if the other side is saying something, make sure that you listen to what the judges are asking. Can you answer that? Can you say, Your Honors, I wanted to address the question that you started with when you asked plaintiff whether Ms. Smith was an employee or an entertainer. She is an entertainer, and here's why, right? You can answer that question. You want to point out any mischaracterizations of the law or facts. So you could say, and again, very politely, right? But notice this goes back to the disagreeing, right? So you can say, Your Honors, my opposing counsel, neglects to mention a key difference between our case and the Hunterson case, which is namely, and you can express that. If there's any question in there that the other side just didn't really answer, you can answer it, right? So, Your Honors, I noticed that my opposing counsel was not able to completely address your question related to costuming. Let me provide you my thoughts about that, whatever. Make sure that you are responding to any, if they say, the defense mischaracterizes the plaintiff as an entertainer rather than an employee, make sure that you can respond to that, right? So you can sort of get up there, and and this is super important if the judges seem like they're jiving with the opposing counsel's argument, right? Make sure that you get up and you kind of respond to that. All right. So what do you need to know? Make sure you know what your facts are. What did this costume look like? How long was she out with maternity leave? Make sure you know what the facts are. think about what the other side is likely to argue, know what you want to say, which is going to be drawn from your brief, and know what your strengths and weaknesses are, as well as whatever your opposing sides are. And I want you to make an argument outline folder. I imagine that many of you are thinking, what the heck is an argument outline folder? I'm going to show you. And by the way, I've seen folks who've been able to do something similar with like an iPad or something like that. If you're more tech savvy, go for it. But for the rest of us, this is how you might do it. What you're not going to do is show up with a giant sheaf of papers held together with a binder clip and flip, right? You want this to be smooth and seamless. Referring to your preparation document should be something you can just glance down at it, glance back up. You're going to smile, put your shoulders back, and answer the question, right? So the first thing that I want you to do is I want you to create your folder by taking 2 file folders, 2 pocket folders, it doesn't matter, and sticking them together so that they overlap. And you've got, side 1 that can fold in, and you've got side 2 that can fold in, and then the bottom parts are overlapping so that you create a trifold. All right. On the outside front cover should be your introduction. Hello, my name is Jennifer Carr. I represent the plaintiff appellant, Joanna Smith. May it, please, and can I get my 3 minutes rebuttal, whatever. Make sure that you have a super quick little statement of what you want the court to do. We're here today to ask the court to reverse the lower court's decision. Your hook that's going to introduce your theme. This is a case about gender-based discrimination presented in the guise of preserving an entertainment experience. And then give your little roadmap. Once you open it, make sure that you have your list of cases, right? So that you can say something like, yes, in the Hunterson case, the court did hold blah, 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 but note that that case is not within our jurisdiction, or note that the facts were very different because reasons, right? So be aware of that. What I did was to have little index cards, and I had them overlapping with the case names at the bottom so I could flip it up and be like, oh yes, the Hunterson case. Judges, lawyers, volunteer judges for mock or moot court tend to like it if you can say, only 2 years ago, a case was decided about a similar issue, blah, 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 that kind of thing. In the middle section, and this is the key thing, right? The middle part's the best part. You're going to have sort of a prioritized version of your argument. And it doesn't necessarily need to be complete sentences, because again, you want to be able to glance down, glance back up, answer the question. I would say you want to think about, okay, what I did was I had in my largest size text, the things that I needed to get out if I had a super hot bench. Then I had sort of my medium points just underneath, right? Where those main points are going to be your section headings from your brief. And then the medium points are going to be, the key parts of your brief within that bit. And then, in the smallest text, what I would say if I got a cold bench that just really was not giving me any questions, make sure you have a conclusion that tells the court what you want, right? For the foregoing reasons, we ask that you affirm, or we ask that you reverse. On your back cover, you want to have scrap paper, and I literally just taped a piece of scratch paper on the back so that I could write down what was the opposing side saying or not saying, and how could I respond to that. Once you've got your folder together, I want you to practice. And that means both, delivering your introduction and your conclusion. It means knowing what your main points are. And again, you're practicing that with your study group. You're practicing that in the mirror. Talk to anybody who will listen to you about it. I also want you to make a list of the questions that you are most dreading and be sure to answer them. And that may be on that side where you've got like, oh gosh, I really hope they don't ask me about, the fact that this whole restaurant was science fiction themed. Because if they ask me about that, it does make it seem like she's an entertainer. And what am I going to say about that? Have an answer ready for that, right? So kind of don't, I think sometimes we kind of, oh God, I hope I don't get that question. Don't do that, right? Like be prepared to answer that difficult question. All right, general presentation guides. I want you to listen to whatever the judge is asking you, right? Because again, maybe this is a hard-hitting question, but maybe it's a softball. And listen to what your opponent says so that you can respond to it. Like we heard Judge Roberts say, answer the question you're asked. So anytime you're asked a question, you should start with yes or no or maybe, right? So have something that you can say in response. Answer that question. Then you can jump into why the question, how your situation is different, or you can, respond in a more fleshed out way. But you want to start with just answering the question. Like, what are they asking you? Answer that question. You want to speak slowly. You want to speak respectfully. And that means being aware also of kind of what your face is doing, right? Like, if you're someone who doesn't have a good poker face and the judge asks you something that you're just like, what is this guy talking about? Be sure to school your face, right? You want to, sort of look like you're listening and you're considering what they're saying. You want to agree with whatever you can, right? So, both my opposing counsel and I agree that Ms. Smith was given an appropriate amount of maternity leave. However, where we disagree is that when she returned, she experienced gender-based discrimination as a result of her pregnancy-related weight gain, right? Agree where you can with the judge. Yes, judge, I understand why that case might be problematic for my client. However, I would argue that actually don't say I would argue, I'm going to talk about that in a second. Instead say, yes, judge, I understand why that case would be difficult for my client. However, that case was decided in another circuit and is thus only persuasive jurisdiction or persuasive authority. And you shouldn't use the same reasoning for whatever the reasoning is going to be. Don't be afraid to ask them for clarification, just like you can do in class. I think what you're asking me is whatever it is. Or if I understand correctly, what you're looking for is a response to whatever it is they're looking for a response to. Don't break credibility, meaning don't mischaracterize things. Don't, sort of summarize things in a way that's not accurate. So, for example, and my ex knows that I tell this joke, but when my middle son was about a year old, my ex came to me and says, Jen, I really want to go see a movie. And by the way, he does oral argument for a living. He says to me, Jen, I really want to go see a movie. And I say, okay, what movie do you want to see? And he says, I want to see the movie I Am Legend. And I say, what's it about? And he says, well, it's about this guy and like the rest of the world gets sick. And he develops this really intense bond with his dog, who's the only like living creature left. And I'm like, oh, that sounds great. We show up. Those of you who know what I Am Legend is actually about are probably laughing. It's a zombie movie, right? And it's true that Will Smith does in fact develop a relationship with his dog, but it wasn't that they were sick. It's that they were turned into zombies, right? So was it accurate? I mean, sort of. Did I ever let him pick a movie again without checking it out myself first? No. So by mischaracterizing facts, by sort of overgeneralizing or undergeneralizing, you can lose credibility. And that's important in real life because you don't want the judges to think, oh, here comes this guy again who mischaracterized the facts that time. It's also important in school because your professors know those cases. They know what they're actually about. You want to make sure that you're presenting it accurately. Don't break character, right? You are an oral advocate. You are presenting your argument. So keep that in mind. Don't, try not to giggle. If you're somebody who giggles when you get nervous, try not to giggle. Try not to, just say, well, judge, I don't know if I have an answer for that, right? You're an oral argument. You want to make sure you're presenting yourself that way. You also want to modulate your voice. So some of us may be very soft-spoken. All right, you need to speak more loudly. You need to make sure you're projecting so you're heard. If you are a big guy, you want to be careful not to be too loud or you're going to sound like you're yelling. So this is where, again, practicing in front of somebody can be really helpful. Are you able to hear me? Or does it sound like I'm angry and I'm yelling? Things that I've heard. With all due respect, that kind of makes it sound like there isn't a ton of respect that's due, but if there was, I would give it to you. Try to avoid that, right? So something that can work better is respectfully. Respectfully, Your Honor, blah, 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 blah. But if you can, I would leave all of that off and just convey respect in your answer and your tone of voice. Something like, as you know, Your Honor. So it's entirely possible Your Honor does know that she's read your briefs, that she's read the cases, and she is ready. But it's also possible that her clerk briefed that stuff for her and she's flipping through the brief trying to find whatever it is you're talking about and feeling like a dummy because she doesn't. Just skip the as you know and say, whatever your argument was going to be after that. Let's say that the judge asks you a question like, well, why does your opponent argue that the woman is an entertainer rather than a server? Or why did the lower court affirm that argument? Don't say you don't know, right? You can say, well, Your Honor, I believe they misunderstand the facts of the Henderson case where the court held blah, 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 blah. Judge says, hey, what relief are you seeking? Don't say, I'll answer that in a minute and get back to reading whatever your argument was. Judge wants to talk about relief, you talk about relief. Sometimes I make the analogy that it's kind of like being on a bad date, right? And you show up and you're like, hey, this is going to be great. We're going to have coffee together. And your would-be date wants to talk about, different types of beetles. And you're like, are you kidding me? But look, here's the deal. If for whatever reason your judge wants to ask that question, you need to answer it. And for all you know, he's asking that question because he knows the guy sitting next to him is hung up on whatever that issue is. And once you get that out of the way, that judge next to him is willing to answer the question, right? If you get a little thrown off by questions, you can always go back to your theme. So, if they say, were these costumes based on Star Trek or Star Wars? And you're like, I don't know. So you can say, well, Your Honor, it's not entirely clear from the record, but they were certainly science fiction based. And then because it seems like they want to talk about costuming, you jump into that part of your argument. So let them kind of direct it a bit. Try not to say I think or I believe or any kind of I language, right? We know it's what you think. We know it's what you believe. We know it's what your argument is. You're up there arguing it, saying it, all of that. So you can just leave that out. You can also, words like my client contends or it's my client's argument, that kind of distance you from your argument and make it sound like, well, that's what they say. But what I say is whatever it is that you say, right? So try not to say that. Just, it's our argument. Or, Ms. Smith is experiencing gender-based discrimination rather than Ms. Smith contends she experienced gender-based discrimination. Also, you don't need to do long factual reviews of the case, right? So I know I said base it on your brief, and your brief probably starts with a statement of the facts. Assume they know the facts relatively well. Instead, jump into the analysis part of your brief. All right. I also don't want you to whine or be pushy, right? So watch your tone of voice and don't, try to push back on the judges when they're asking you something. Once the judge asks you a question, don't wait for another question. Instead, jump right back into your argument. And like I said, if they're pushing you to talk about point number 2 rather than point number 1, you start with point number 2 and then you go back to point number 1. I don't want you to be nervous. So my first in-school oral argument, I had practiced standing at a podium that covered my entire body. And so I could do this thing where I tapped my foot and nobody could tell. When I did my actual oral argument, I had a podium that came here and then was like at my waist basically, and then was placed on a table so you could see my feet and you could see me jiggling my foot. You also want to be careful about using a lot of movement. So you can tell I use my hands a lot. When you're doing an oral argument, part of being more formal is to try to stand still. So think about placing your hands on the podium and you want to use your hands for emphasis. Your Honor, I have 2 key points. First, blah, 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 blah. Second, blah, 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 blah. Put your hand back on the podium. It shouldn't move again for a while, right? So really think about using your body language in addition to just your voice and the substance of your argument. Last, don't try to be somebody else, right? So I know I said, like, look at other advocates, see how they argue, see how they speak, see what you like. And you're in the process of developing your own oral argument style and voice, but you don't have to be somebody else. You can just be yourself. It's okay to, I know my tone is always going to be more conversational than some other folks, but hey, that's okay. I need to be formal, but I can still have that conversational tinge to my argument that other folks might not have. It's okay to, bring your own viewpoint, argument style, way of being into that argument. And it makes you more believable as an advocate. You might feel like, oh my gosh, Jen, that was a lot. But if you have questions, don't hesitate to ask. One question I sometimes get is, what do I do if the judge asks me a question I don't know the answer to? So one thing that you can do is respond as you would in real life, right? You could say, Your Honor, I have to admit I'm not familiar with the, Schmidt versus Jones case, and I will need to look that up, and I will provide you with a supplementary briefing within 24 hours. That kind of thing is appropriate, right? Try to answer it, but if you can't, it's always, I'll provide you with, I'll do additional research and provide you with a supplementary briefing within 24 hours. We have a question in the chat, so I can answer the question. If the judge is, really just like not listening to you, like just will not, acknowledge your argument, I would say, try to ignore it as best you can and direct your argument to the other judges. Do kind of try to treat it like a conversation, try to answer the questions they're giving you, and try to respond respectfully, even when that judge is perhaps not being respectful. And don't, be aware that the judges that are either observing you because this is moot court, or the other judges on the bench are going to know whether you were accurately answering the question politely and kindly in the face of that kind of discouragement or not, right? Like, it's not going to go unobserved. Nope, got another question, which is, Stephanie says, what if I don't understand a word in a question that they ask due to a language barrier? That is such a good question. And that can happen because maybe there is like a language barrier. Maybe there is maybe you're just struggling to hear them, right? So I would probably repeat back to them and say, Your Honor, what I think you're asking is, and give it the best guess that you can. You could also say, Your Honor, I'm so sorry. I'm not sure that I completely understand your question. Would you mind rephrasing it? Right? So again, this is one of those things where it's like, it is a conversation and it's okay to ask for clarification. You're in a joint search together for the truth. And if you, are respectful, you can absolutely ask for clarification or rephrasing. You can even say, Your Honor, I'm not entirely sure that I understand, the second word in your question or whatever, right? Or sometimes you can, one step that you can use, and this is true even if you do understand, you can say something like, Your Honor, I think you're asking me about X. Is that correct, right? Ask for the clarification. You can do that. You can also say, let's say the judge says something like, isn't it true that Ms. Smith was in fact an entertainer? You can sort of address the underlying question that they're asking. You can say, Your Honor, it's true that she was wearing, a uniform that presented as a science fiction costume. And it's true that her job, involved presenting the clients of the restaurant with a particular type of theme. However, the main part of her job was, working as a waitress. It was her job to take orders and then deliver food according to those orders, which makes her primarily a waitress, where you're kind of like, you're answering the question, but you're really kind of getting at whatever the underlying concern is, that kind of thing. So Stephanie, that's a really, really good question. And what I would do, again, treat it like it's a conversation, like it's a joint search for the truth, and just say, Your Honor, I think what you're asking is X, or Your Honor, I'm not sure I understand your question. Would you mind rephrasing it, please? That's totally fine. They're used to that. It's absolutely acceptable. Practice delivery of those lines with a friend or with a mirror or whatever, so you can kind of do it in a way that feels respectful but confident. Well, don't forget that we are available if you would like to chat with one of us. We're available to help with any aspect of law school. And go ahead and just remind you again of our packages. And like we said, we can go through your oral argument. We can look at your brief. We can also, help you with practice questions or concepts that you are struggling with, right? You're sitting there going, what the heck am I supposed to do with the rule against perpetuities? Or what is going on with the, mailbox rule? Come talk with us. We're happy to answer those questions. I will let you guys go. Good luck in school and in your arguments. And we thank you for your time and your attention.